All right, good evening. This is the March 5th, 2014 meeting of the Join Us. I pledge of allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening, Mr. Chairman and members of the board. Is this on?
Is that on?
Are we on?
Testing? No? It's not on.
Says it is.
Okay, go ahead.
Great.
Go ahead.
The first item on the agenda this evening, the Planning Department recommends the following items for adjournment as we have insufficient information to act upon them. Under Part 1, Item 1, 2011-01, All Seasons Motor Lodge. Item 2, 2012-04, Storybook Homes. Item 3, 2012-02, Carlson Associates. Item 4, 2009, FB4 Realty. Item 5, 1157, Map of Court, Kings Park. Item 6, 773, Scholar Estates. Item 7, 1092, Winston's Run. Item 8, 1139, Jenna Court. Item 9, 288, Olivia Estates. Under Part 2, Item 10, 2010-06, KVC Holdings. Item 11, Case 911A, Glen Hill Northern. You'll notice that the applicants have requested adjournments for Carlson and FB4, and note that the Map of Core, Winston's Run, and Jenna Court have been scheduled for March 19th at the board's request. Mr. Chairman, these are the items the Planning Department recommends for adjournment this evening.
Anybody present who wishes to be heard in any of the items that the Planning Department is recommending for adjournment? Hearing none, a motion, please.
I move that we adjourn items 1 through 11 as read.
Second.
All in favor?
Aye.
Opposed? None? So adjourned.
Mr. Chairman, the next item on the agenda under Part 3, Item 12, is a waiver request for Yellow Top Farm Estates, Section 1, 1043. However, the applicant does not appear to be present.
All right, well, let's just go to other matters and correspondence, and then if they're not here, we'll proceed accordingly.
Sure.
Which will probably be an adjournment, but so.
Okay. The next item on the agenda is the adoption of the minutes from the February 5th meeting.
Does everybody have a copy of the minutes? We need a motion, please.
I move that we adopt the minutes of February 5th, 2014.
Second.
All in favor?
Aye.
Opposed? None? Minutes are adopted. I see there's 2 items of correspondence.
Yes, Mr. Chairman, if I could address those for the moment.
Yes, please do.
Because this has been a matter that the board has asked questions about with regard to this decisions, and actually some of the residents have called us. And I'll give the board an update as to where we stand right as of today, because I've had meetings with the town attorney on this matter. As you are aware, the applicant here has requested a zone change in the Old Northport Road area. This is Carlson and F4B Realty, and there's also other parties that are involved in that particular zoning request. A large part of that is also involved with regard to violations that are occurring in that particular area. So these matters are also in court. And I think the board is well aware of them. I don't wish to discuss the legal matters. However, what has happened is that the applicant proposed a partial solution to the yard waste processing facility, which they had asked the board to consider approving both an amendment to the code and a facility like that in the for a facility that would be constructed entirely with indoors. In other words, instead of processing yard waste outdoors, which is currently happening, it would be processed indoors. There's been actually several meetings on this particular proposal because there's 2 levels of concern. The first level of concern has to do with the types of processing. And it has the type of processing has to also to do with whether it's profitable or not. The least objectionable type of processing indoors is just simple shredding and repackaging of materials. You take in trunks and you shred them up and you make mulch and you bag it and you sell it. That's the least profitable use. The most profitable use has to be what they call anaerobic or aerobic digestion, whereby it's a form of both composting and generation of gas, which they generate use for natural gas, production. The problem is that as you go up from one spectrum towards the highest spectrum, the number of issues of concerns like odor, noise, production, and other things increase, and there's issues with that. So we were going through all of that. While we were reviewing that particular issue, there was a separate issue that was occurring simultaneously that was brought up, and I believe I mentioned this to the board about 6 weeks ago, that the New York State DEC, under Part 360 of the Environmental Conservation Law, regulates these types of facilities. And there was a concern that if the town permitted this, would the DEC preempt the town from doing the type of oversight that we were considering with these types of facilities? Because all the proposals that we were going with had some form of either daily or hourly or some form of monitoring on the site themselves. And the opinion of originally of the town attorney was that there was a strong possibility. We revamped the proposal and submitted one to the town attorney about 3 weeks ago for a new type of procedure called like a licensing procedure rather than a zoning procedure. The town attorney just this week got back to me and said it's still going to be that the state's going to preempt us under their regulations. What this means is I'm preparing a memo which is going to the town board on tomorrow, which is going to outline the problems that we face at this point, which means that unless we find it out to this particular issue, we can't go along with what the applicant is proposing, and we're going to have to figure out some other solution. In the interim, we're suggesting that we have a sit-down meeting with DEC, and it be a high-level meeting because this is an issue for which the DEC may not want to preempt the town if we're going to go ahead with this type of facility. We feel that there is a legitimate local public purpose in us monitoring these particular facilities. I don't know if this will be successful or not, but that is really why we're delaying this. But we hope to have this resolved or at least have a discussion within the next month. But I'm sending that memo to the town board. I'm assuming that they're going to say go ahead and set up a meeting with DEC. And at that time, I hope to bring members of the town board along with me to the meeting because it really requires that type of influence in order to have this done. So that's where we stand with regard to the zone change. I will tell you that I spoke with some of the residents in the area. Some of them are not happy about this because the applicant they feel come spring is going to continue to operate that facility. I'm also mentioning that to the town board so that they're aware of this. And that's where we stand and why we're going along with the adjournment at this point. Okay?
So would it be fair to say that these matters will probably not be heard until after you have this meeting with the DEC, if in fact you get it?
Yes, I'll report. What I'm going to do is I'm going to send the letter to the town board tomorrow. I will advise this board, since you're handling the zone change, by the next meeting what the results of that decision was so that you'll have an idea as to how you wish to proceed.
You'll be trying to get some type of a waiver from them to allow the town to regulate where maybe they would otherwise be regulating?
I really don't at this point have a particular plan in mind, but we have to do something with regard to this because the DEC wants us to do these type of activities. At the same time, they're preventing us from doing the oversight that we think is essential to make them compatible within the area. And we think these type of facilities are worthwhile to consider. But then again, they have potential to be obnoxious and to be of harmful to the surrounding community. We know what we want to have checked.
Right.
And we, I don't know how else to put it to them, that maybe we could get some state legislation that allows us to have dual control or something like that. I don't know what it is, but if they don't agree to this, then our answer is going to be, we don't want these facilities in our town.
Maybe there's also some mechanism where they can grant a waiver in this particular instance to us, to allow us to regulate it in their place. But that's what you'll have to explore.
Right, we'll have to explore that. I would think, hopefully there would be, but this is government sometimes. We're not always as logical as we should be.
I think
Okay.
my only concern would be to ensure that, I mean, there was a huge community presence here when this was going on, and I guess if you give us periodic updates on, it'll be available for them to see on Channel 18, and that's the best we can do to keep everybody informed, right? I mean,
At this particular point, yes. On the phone today when I was speaking, I will tell you, some of the residents understand completely of this, but the ones that are closest to this facility, I think, are fearful that once the spring occurs, right now there's no particular problem because of the winter, but once the spring comes, they feel that the issue will reemerge, and there's some validity to that concern because those products have been sitting there all winter, and we're going to have to do something with regard to that. So I'm going to bring this matter before the town board. I'll let this board know what the town board's response is, and then at the next meeting, I'll report back to this board. We'll make it an official
On the calendar,
item
yeah.
on the calendar,
Fine.
and then the board could decide which it wants to do.
Okay.
Okay?
Thank you.
Thank you very much.
Okay.
All right, well,
It's
the
8:15.
other matter that we have on is item number 12, Yellow Top Farms, 1043. The applicant is not here. It's 8:15. I believe that the applicant should be here when we act on this because there are some conditions that are set, and I think it would be appropriate for us to have the applicant hear those conditions and make sure that they agree with them and have no objections to them before we act on it. So with the applicant not here, I believe the best way we should proceed is to just adjourn it. So we need a motion, please.
Plus, it's our policy to require
Right.
an appearance.
I don't see how we could act on it without him here. So they're not here. Maybe if you want to reach out to them and see what's going on.
They were aware it was 8 p.m.?
Yes.
Yes, Agnes made several phone calls to remind the applicant because they weren't responding initially. So even the company that's doing the pool was aware of the fact of,
Okay.
Well, here comes somebody now.
Ooh, just in time.
Are you here for the pool
Yes.
in Yellow Top Farms? Okay, then we don't have to adjourn it, I guess.
okay.
Sorry, I went to town Smithtown, you can say on the paper what that was.
Oh, okay.
Okay.
Do we need anything, any affidavit or anything from her?
Affidavit of
Affidavit of
posting,
posting?
and then Alex would read.
He'll read
the
it, right, then he'll read it.
Okay.
I'll take it, but this is what we're looking for. Okay, thank you. Okay. The applicant is requesting to modify a limited access and planting easement on Lot 17 within the subdivision known as Yellow Top Farm Estate, Section 1, 1043, in order to permit a 20-foot by 42-foot, 840-square-foot in-ground swimming pool 10 feet into a limited access planting easement. Additionally, the applicant is requesting a variance from the Board of Zoning Appeals to alter environmentally sensitive lands, ESL. Before the BZA can act, it is required by Chapter 2776 of Town Law to consider the Planning Board's comments to the BZA. The map of Yellow Top Farm Estate Section 1 was filed on September 5, 2003. Section 2 was filed on April 8, 2006. The final map of Yellow Top Farm Estates 1043 was approved by the Planning Board in two sections. Section 1 was approved on February 19, 2003, and Section 2 was approved on July 6, 2005. This application was approved for a total of 34 lots, 20 in Section 1 and 14 lots in Section 2. The final map of Yellowtop Farm Estate Section 1 contained a 975-foot-long, 25-foot wide limited access and planting easement along the western edge of the property, located in the rear property lines in 8 lots, 13 to 20, as well as in the common area. The purpose of this easement was to provide a planted buffer between the proposed homes on Yellowtop Lane and Route 347 and Mount Pleasant Road, as well as between the homes and the commercial properties on Route 347 that abut the residences. Lots numbers 15, 16, 17, and 18 back up to a parcel zoned NB Neighborhood Business, currently occupied by a Friendly's restaurant, a World Tile showroom, and a 7-Eleven convenience store. The 8 affected residential lots were planted with a double row of trees approximately 15 to 20 feet wide along their rear property lines. On January 17, 2014, David Katana submitted a waiver application to the Planning Department, requesting that the limited access and planting easement be modified to allow a 20 by 42-foot swimming pool 10 feet into the easement. Because a test hole encountered groundwater at 9 feet 3 inches below the surface, this proposal also includes a variance application for the alteration of environmentally sensitive lands in the form of high groundwater less than 10 feet below the surface. In addition to the Planning Board waiver request, the applicant is requesting a Planning Board recommendation to the BZA for this variance. The waiver application was distributed to all concerned departments for review. The Highway and Traffic Safety Departments have no objection to the applicant's requests. The Engineering Department had no objection to the waiver request, but noted that there is a roof dry well in the rear yard that must be maintained or else replaced under the discretion of the Engineering Department. They also noted that in accordance with Chapter 252(6) of the Town Code, all water emptied from the swimming pool must be disposed of in a leaching pool on the owner's land, which shall be indicated on the plan submitted for a building permit. The board reviewed a similar application from the applicant's neighbor on November 20, 2013. At that meeting, the board approved the request of a Dionysia Chardavoine to modify the limited access and planting easement in her rear yard to permit the installation of an 18 by 30 foot, 540 square foot pool 15 feet into the 25-foot planting easement. Allowing for a 2-foot margin around the pool, the board required that at least 8 feet of the buffer remain densely planted in this area. Although this application is for a larger pool, the depth of encroachment is less by 5 feet. In the case of Chardavoine, the board permitted approximately 450 square feet of encroachment into the buffer. This application is for approximately 420 square feet of encroachment. The Planning Department reviewed this application and noted that many of the surrounding homes have similar in-ground pools, including at least 3 on properties with a limited access and planting easement. One of these homes is the aforementioned case. The installation of the pool would allow 15 feet between the shared property line with the commercial properties and the pool. The commercial property is mostly grass in this area, and the rear of the World Tile building is approximately 100 feet from the shared property line. The purpose of this easement was to provide a planted buffer between the backyards of the residences and the busy roads and commercial areas. As part of the reconstruction of Route 347, the New York State Department of Transportation is in the process of installing a wall along the north side of Route 347. This will help reduce the sound and visual impact on these properties from the road. The easement serves primarily to protect the residences rather than the commercial properties. Therefore, the Planning Department does not object to the request of a residential property owner for minor modifications to the buffer in their own rear yard. However, in order to preserve some buffer between the commercial and residential properties, the Planning Department recommends that the remaining 15-foot wide portion of the limited access and planting easement between the side of the pool and the property line remain densely planted, with the exception of a 2-foot margin for the swimming pool. In past cases where a resident requests a reduction to or elimination in a buffer adjoining a commercial property, the town has required the applicant to file a covenant acknowledging that the buffer was modified at the request of the homeowner. This was done so that future owners would be aware the town or adjoining commercial properties did not cause the reduction in the buffer. With regard to the environmentally sensitive lands, it appears that the groundwater is far enough below the surface as to have a minimal impact. Construction permits for the pool will require that the water is disposed into a leaching pool in dry soil. Therefore, the Planning Department has no objection to the recommendation of the Board of Zoning Appeals. The Planning Department offers the following resolutions for the Board's consideration. Be it resolved that the Planning Board hereby approves the request of David Katana to modify the limited access and planting easement in the subdivision known as Yellowtop Farm Estates, 1043, Section 1, within Lot 17, to permit the installation of a 20 by 42-foot in-ground pool 10 feet into the easement, as depicted in the plan dated January 17, 2014, subject to the following conditions. A. The proposed pool shall comply with Sections 322-17 of the zoning ordinance, swimming pools, and Chapter 252 of the Town Code, swimming pools. Subject to Chapter 252, Section 6, all water emptied from the swimming pool must be disposed of on the owner's land. Provisions for a leaching pool shall be indicated on the plan submitted for a building permit. B. Per the engineering department, the existing roof drywall in the rear yard must be maintained or else replaced under the discretion of the engineering department. C. At least 13 feet of the limited access and planting easement between the pool and the rear property line shall remain densely planted with evergreens of a size and species acceptable to the planting director in accordance with the approved planting plan for the limited access and planting easement for Yellowtop Farm Estates. And D. The applicant shall file a covenant on a form acceptable to the town attorney, acknowledging that the number of plantings in the limited access and planted buffer adjacent to the commercial property were reduced at the homeowner's request. And be it further resolved that the Planning Board hereby makes a recommendation to the Board of Zoning Appeals to permit the alteration of environmentally sensitive lands, depth to groundwater less than 10 feet, with the construction of a 20 by 42-foot in-ground swimming pool on Lot 17 of Yellowtop Farm Estates, 1043, Section 1.
Ma'am, are you here on behalf of the applicant in this matter?
Yeah, that's my husband.
Can you please go up to the microphone and give your name and address?
My name is, hello, okay. My name is Nitsa Kanata at 21 Yellowtop Lane, Smithtown, New York, 11787.
Okay.
Nitsa, N-I-T-S-A.
All right, did you hear the recommendation of the planning department regarding this matter?
Did I hear?
If they just read it.
Oh, yes.
Okay. And are you in agreement with the recommendation as well as the conditions that are going to be attached to it as read?
Yes.
Do you have any questions you want to ask of us or anybody from the planning department at this point?
Just one thing. Our plan was to have done this back in the fall, so how long is my permit going to last? Because we might do it in the fall now.
You want to do this in the fall, you said? This should, all your approvals, that when you go before the Board of Appeals, they'll give you a 6-month approval window, and you can easily get an extension. What I would do at the Board of Appeals would mention that it's a fall construction, so that they would be aware when you put in if you put in a request for an extension, that it'll be quickly honored.
Okay, so in other words, if you grant me
They
the-
actually may even give you a 9-month approval window, too.
Okay, but if you do grant me the permit now, then in case we do it in the fall, it'll be okay?
Well, the building, you have several permits. You have a Board of Appeals, which has automatically a 180-day limitation on it. The board may grant you longer if you so request it. The building permit that you get, that's from the building department, is generally good for 2 years.
Okay.
You should see what they have to say with
Okay.
regard to that, but that's generally good for 2 years on top
Okay,
of that.
great, thank
Ma'am,
you.
just so you know, make sure we understand what's happening here, there are two issues. One is the modification of the planting easement. The planning department has recommended that we approve that.
Right,
The other issue relates to the groundwater. That jurisdiction to decide that issue is with the zoning board of appeals, not us. But we have to make a recommendation to them, and then they will decide it. So
right,
that's what we're doing tonight, these two things.
okay,
And then the groundwater issue has to go before the Board of Appeals, and they have to make a decision. But based upon the planning department's recommendation, we're going to recommend that they approve it.
right,
That's
okay,
what's
thank
happening here
you.
tonight.
Okay, thank
Okay?
you. Mm-hmm.
Anybody in the audience who wishes to be heard on this? Any questions from any members of the board? Okay, we need first a motion on the modification of the planting easement.
In the matter of Yellowtop Farm Estates, number 1043, Section 1, Lot 17, regarding the limited access and planting easement for the installation of an in-ground pool, motion to adopt the resolution as read in accordance with the recommendation of the Planning Department.
Second.
All in favor?
Aye.
Aye.
Opposed? None? The motion carries and the resolution is adopted. Now, can we please have a motion on the resolution concerning the recommendation to the Zoning Board of Appeals concerning the groundwater issue?
In the matter of Lot 17 of Yellowtop Farm Estates, number 1043, Section 1, regarding the recommendation to the Board of Zoning Appeals, I move that we adopt the resolution as read in accordance with the recommendation of the Planning Department.
Second.
All those in favor?
Aye.
Opposed? None? The motion carries and the resolution is adopted. Thank you, ma'am.
Ma'am, if I could also mention, if you need a copy of the survey supplied by the engineering department indicating the location of your dry well, we can get you a copy of that for your pool's construction. No problem.
That's it?
Do you need them back? Okay.
You're done here tonight. Thank you. Have a good night. Don't worry about it. No problem. All right, motion to adjourn?
Motion to adjourn.
Motion to adjourn.
Anybody want to second that? Second. All in favor?
Aye.
Aye. Opposed? None? We are adjourned.